three pieces of paper. You should all have a white file now, which is in response to Clark, who asked us to prepare a schedule of the references in our marked up document. What we've done is tab 1 is a reprint of the document with the references in it, and then tab 2 is simply the schedule, depending on whether your lordships prefer to keep the marked up copies your lordships already have.
Thank you
but
very
that
much.
that is what that document is. Your lordship should also have, prepared by Messrs. Vincent Masons for Müller, copies of the witness statements, which are in a bound volume like this. And separately, knowing that they were preparing that overnight for your lordships, there's a single sheet of paper where we have been through and we believe identified all of the references in the various witness statements to paragraph numbers dealing with MF1. So between that document, the extracts from the transcripts that I handed up yesterday, and the witness statements and the transcripts, your lordships, I should believe have a complete cross-reference to the evidence on MF1. I should say that this schedule has not been agreed by my learned friends. There simply wasn't time to get it to them, so any errors are entirely ours, but I believe it's comprehensive. Then again, in answer to my Lord Clerk's request for a draft order, your lordships have two draft orders. One is very simple, which is if your lordships were minded to go with the no contract route, it's a simple dismissal. The second draft order is the one relating to the MF1 terms. I hope it's self-explanatory. It effectively follows the paragraphs in the case that I identified as containing what we say was agreed. We have put in square brackets and italics issues which the court, if you were minded to take that route, would still have to determine. So, for example, in paragraph 2(1) on the second page, we've indicated that, as your lordships are aware, given the relevant period for performance was up to the 29th of June or the 5th of July, your lordships may wish to declare that part of one of the terms was not considered as part of the agreement, namely the provision of an advance payment guarantee, because it didn't happen, but the payment was nevertheless made.
Yes.
And that's agreed. Your lordships will see that we contend for at the latest 5th of July, and I'll explain why that date is important in due course. The other matter your lordships ought to be alive to, apart from, obviously there is a debate between my learned friend and myself over whether there was a cap on performance liquidated damages, and we say there is definitely a cap. But in Roman 4 on page 3, there is an issue about the schedule which recorded the, sorry, not that one, Roman 7 on page 5. There is an issue in relation to the approved programme, and I'm sure your lordships will be familiar with the general scheme of these types of contracts, that there is should be an approved programme agreed very shortly after the contract is executed. It's clause 17 of the MF1 terms. That is then used as the baseline to assess variations, delays, all that sort of thing. There were in fact two programmes in the negotiations in this case. The one that Mr. Brown identified as being agreed is the original programme, assuming an original date for issue of free-issue equipment. The one that the judge found relevant to the contract he found showed later dates because it took account of delays that had already occurred. So there is an issue that your lordships would have to grapple with as to which is appropriate. We obviously say it's the earlier one. If the contract is retrospective, it should reflect what was agreed at the outset, not taking account of delays that occurred in the intervening period. But I don't intend to develop, unless it would help your lordships, I don't intend to develop that further. But it is quite an important point, because it may affect entitlements to delay, loss and expense, things like that.
But your case is the bits in which are not in italics.
My lords, our case, the bit's not in italics. The italics are there. There are issues which your lordships would need to resolve. They haven't been debated before the Court of Appeal because we didn't get to this argument. And it depends on your lordships whether you would like arguments addressed on it. But your lordships would need to make a decision either way. And we've tried to identify where we believe there is a choice to be made for your lordships in declaring what the terms of the contract are that would be necessary for the parties to understand going forward. They're limited.
Yes. If one were to postulate that the contract was concluded on the 29th of June or maybe even on the 5th of July as a result of the parties being agreed that there was nothing outstanding upon which they were disagreed, would the analysis then be that when you feed in the performance, insofar as no guarantee was provided by the parent company, that would be a waiver of that requirement because it had been agreed that that guarantee would be provided.
Exactly.
And insofar as the timetable had changed and the sequence of installation of the lines, that would simply be a practical variation on the terms that had been common ground on the 29th of June.
Our case would be that in relation to the programme, it would be the original programme which was agreed, which showed the original dates on which the price was met. I suspect my learned friends will say that the overall programme that was submitted on the 29th of June, which took account of delays, should be the programme for any contract your lordships find, as the judge found, but we say that deprives us of the variation that has occurred as a result of their delay in delivering equipment. And that's so it would be a month or so delay where we'd have a debate before the judge at first instance. But that's the choice for your lordships as to which it is. And if we're right, then the original programme is the approved programme for the purposes of Clause 17. The overall programme simply is an update to that showing what delays had occurred. If they're right, the overall programme of the 29th of June would be the approved programme. That's the choice. My Lords, subject to any matters your lordships wish to raise, if your lordships will permit me, I'd wish to go through how the case was developed and a brief look at the facts before turning to the analysis of the law. The reason for going to how the case was developed is because in my submission it is important that your lordships understand the significance of the 29th of June and 5th of July dates, and that there was in effect common ground between the parties that this contract was subject to contract. So when your lordships are considering the alternatives, lordships need to bear in mind the way in which both parties presented their case, which effectively came to the same terminus, namely it was a subject to contract case. And I'll show your lordships expressing, if your lordships will bear with me, because that may explain then why there is no evidence in relation to performance after the 5th of July, and why the 5th of July date certainly is a key date. The second reason for going to it is because of the allegations made by my learned friends in their case, that somehow there's been a procedural impropriety, and it was a new point developed by us in the Court of Appeal, which was not. The reason for going briefly to the facts, although I appreciate your lordships have seen the statement of facts and issues, is to show your lordships that really the judge in many ways was right in his analysis of the facts, but also that the performance-related liquidated damages were effectively the first thing that was agreed. And were always agreed throughout the contract period. It wasn't a matter of debate, so that the only issue my learned friend has identified, as I understand it on the MF1 form, relates to that one clause, but actually that had been agreed from the outset. And it's striking that that's the first time we've heard that argument, which may give an indication that my learned friend is not as confident as he might otherwise be in his overall case. But it's the first time they've ever suggested that the rest of the terms might apply, that you would be striking out one clause, but I had to deal with that in front of your lordships. So if I may start with Müller's contractual statement of case, which your lordships have in tab 10 of part 1. And your lordships may recall that certainly we suggested that Müller's pleading of its case on contract was unclear. And that led to an order, which your lordships don't need to turn up, but have at tab 16, paragraph 2, that they should plead out their statement of case separately on the contract. Your lordships have it at page 188. And that then we should respond to it, and then that would form the basis of the arguments on the contractual statement of case. If your lordships take up at page 188, this is the document they produced, the pleading they produced. The relevant paragraphs your lordships have at page 195.
This was at a time when your case was that the contract had been concluded by the 1st of March.
Our case was always that it was, at that stage, the letter of intent contract, exactly, my lord. But you'll see that that then developed in our response to this document. And these are the pleadings which contain the parties' respective cases. In the case of Müller, their statement of case replaced what they had previously pleaded. and your lordships get that from the paragraph 2 on page 188. This statement of case is intended to replace paragraphs 45 to 50 of their defence and counterclaim and their schedule. So if one goes forward to page 195, paragraphs 41 and 42, they set out the extracts from the email of the 5th of July your lordships have already seen, and then at the bottom of the page in paragraph 42 say, in the premises, on 5th of July 2005, RTS and Müller agreed the terms of the proposed written contract between them, and the draft contract was ready for execution by Müller and RTS, the final draft contract. The final draft contract was not in the event executed by Müller or RTS. They then deal with the payments in 43 and 44, and they say at 49, although the final draft contract was not executed by the parties, Müller and RTS intended that the goods and services to be provided by RTS to Müller would be provided pursuant to a contract between Müller and RTS. As set out in paragraphs 43 to 46 above, and in the defence and counterclaim, RTS provided certain goods and services to Müller, and Müller made certain payments to RTS in consideration of those goods and services. The goods and services provided by RTS were provided by it in purported compliance with the URS, the FDRS, the assumptions for pre-issue equipment, the KPIs and the test plan, all of those being contractual schedules. And if your lordships can go on, it says, in the premises, Müller and RTS had an intention to create contractual relations when RTS provided the goods and services and Müller made its payments. It is Müller's case, on or about 26th of May, alternatively 29th of June, 5th of September, they entered into a contract, and then they rely on the 2 emails that the judge found. So that was their pleaded case. Our response comes in the following tab.
Which involves a non sequitur, doesn't it?
It does, my lord.
Because if the contract, there was an intention to create contractual relations when RTS provided the goods and Müller made its payments, well, that wasn't, at least for the most part, there had been a previous payment, but it's not suggested there was a contract then in April. So it was either 5th of September or afterwards.
One would think so. That is not how it was developed, and your lordships will see that in a moment. It came down to the 29th of June.
So let's carry on.
But the non sequitur is also that, of course, this is in relation to their identifying schedules of a document which they have already identified as a final draft document which requires signature as being the basis for the agreement. And the period within which, as it turned out, the period within which they're alleging for the first 2 dates and a contract was made was during the period in which it was still definitely under negotiation, and they themselves have pleaded.
It doesn't seem to me the slightest bit of a non-secular section if you say we read all the terms, we're just going to put it in writing, at least that's what we intended, but then actually we delivered the goods without bothering about putting it in writing. Perfectly logical conclusion that there was a contract on the agreed terms. If that were the way it was run.
If that was the way it was run.
Yes.
The RTS response is the next tab, tab 11. If I could take your lordships to page 221, paragraph 50. Paragraph 53 of the defendant's contractual statement of case is denied. That's the paragraph which set out the schedules that they rely on for their contract. The defendant has, without explanation, selected only certain component parts of the anticipated contract that it intends to rely on to support its case, despite other documents or schedules being referred to in the emails upon which the defendant relies to support alleged agreement by RTS to those documents listed in paragraph 53 of the defendant's contractual statement of case, i.e. the emails of the 26th of May and 29th of June. Most notably, the defendant excludes the terms and conditions of the anticipated contract. By excluding the terms of the quotation and the terms and conditions of the anticipated contract, the defendant's construction of the contract between the parties does not include any commercial terms. This was not the intention of the claimant, and the claimant believes it was not, nor could it ever have been, the intention of the defendant. So, absolutely crystal clear that on the pleadings, there was an issue as to whether or not there was an intention to contract without commercial terms.
Strictly, that's a plea of facts which are completely irrelevant because one's concerned with an objective construction of what happened.
My Lord, the point is made that
Yes.
the issue is still there, and your
Yes.
Lordship, if I can take your Lordship back to paragraph 9, page 207.
And if one says objectively that was not, then you're fine.
But, my Lord, yeah, but it was clear, and it's clear enough that
Yes.
there is an issue
Yes.
about it. There was no intent to contract,
Yes.
whatever it may be. Paragraph 9, if contrary to the claimant's primary case on the contract, the quotation is not incorporated into the contract, or clause 3.4 thereof is not incorporated, and or the contract formed by the letter of intent has terminated, and there is no other contract which governs the relationship between the parties, that's a no contract fee, which would entitle the claimant to payment, the claimant will claim the costs it has incurred but not paid in designing, engineering, building, delivering, installing, and commissioning the equipment for the defendant on a quantum merit basis. So again, quantum merit, absolutely an issue. And then 19 and 20 on page 209 to 2010. However, the contract then under discussion was never agreed or finalised. It is noted that the defendant does not allege any agreement or finalisation of a contract based upon the terms and conditions under discussion in May 2005. And such contract is inconsistent with their counterclaim, they set out why. And it deals with limitations of liability. 20. Without prejudice to the claimant's case that there was no such contract agreed or finalised, again, no such contract, and the letter of intent continued to govern the relationship between the parties. If there was any subsequent agreement as to terms, it was an agreement as to the terms and conditions identified in the amended form MF1. So it is absolutely right, clearly on the pleadings. Our primary case was, at trial, letter of intent contract. Secondary case, if there is a contract, MF1. But if there isn't a contract, because as a matter of logic there's a gap, it's a quantum merit claim. And that is clear that the parties understood that, because if one goes forward to tab 17, one has, at page 265, an order which your lordships may, and certainly we regarded as unfortunate, in that if ever there was a case where preliminary issues were not appropriate, it was this one. Happily, we suggested that to the judge at first instance. Unhappily, he agreed with Müller, who said no, preliminary issues would be a very good idea. But the directions were given for preliminary issues.
Where have we gone?
Sorry, tab 17, page 265.
Yeah.
I must say that this is the time at which I would expect very serious consideration to have been given to mediation.
Lord, the parties were fairly intransigent. The positions were hardened. Our submission was very clear, repeatedly made, that this was a case where it would only settle because if there was a determination on liability. And what ought to have happened was that there should be a trial on liability with quantum to follow, because neither party was accepting liability. There had been a mediation prior to this. Müller took a different view and proposed preliminary issues, which we said, rightly, I believe, would never actually resolve the issue between the parties, because even if you resolve the issues on the contract, there would still be lots of factual debates on liability. And unfortunately, easy to be wise with the benefit of hindsight, the judge agreed with Müller, but that's why we're here. One then has the preliminary issues at page 269. Preliminary issue 1.2. First part, did the claimant and the defendant enter into a contract after the letter of intent? So it's capable of answer yes or no. If no, then there is no contract, assuming we've lost on the letter of intent contract. If so, what are its terms? In particular, what documents does it incorporate and or evidence in? Does it include the draft terms and conditions which are based on MF1? And then 1.2.4, what is the payment obligation of the defendant, whether under the contract and or by way of quantum merit? So the parties identified in the preliminary issues the very matters which we are debating before your lordships. It doesn't, however, end there, because if one then goes to part 2 of the bundle, volume 2 at tab 80, one finds Müller's skeleton argument for the actual preliminary issues hearing. It's volume 3, I believe, actually.
Sorry, what tab?
It's It's part 4, it's tab 80.
I find these extremely confusingly titled. Part 4, you said.
Appendix Part 2, additional fourth
Part
bundle.
2, originally volume 1 of 2 and volume 2 of 2, and then additional bundles have come in, so they're now part 2.
Additional fourth bundle, thank you. Okay. The trouble is they all look the same. And the authorities bundles look the same as the factual bundles. Anyway,
My Lord,
tab what? 81, you say?
no, 80, my Lord.
80.
Muller's skeleton argument for the trial. If I could go to page 1319. The bottom of the page, they deal with, under the heading, the final draft contract, that is the contract as at the 5th of July, subject to those emails your lordships have seen. In the period prior to the 16th of May 2005, the parties negotiated detailed contractual terms and conditions. This process culminated in the final draft contract. It's identified and says the compromise wording was agreed on the 5th of July, together the final draft contract. The agreement was ready for execution at that stage, but was not in the event executed by Müller or RTS, and it is Müller's case that it does not have contractual effect. At all material times prior to the 5th of July, it was the intention of the parties that the detailed terms to be negotiated by them would not have contractual effect unless and until the document was formally executed by them. This intention is clearly expressed in, for example, the letter of intent and Mr. Morris's email, Mr. Morris being the solicitor at Müller, of the 13th of May 2005. The negotiations were, in effect, conducted on a subject contract basis. So one can imagine my bafflement when my learned friend stood up and suggested that we were elevating the contract to a subject contract case for the first time before your lordships or the Court of Appeal, when in fact it was his case. The problem is he's realised it proves too much for the reasons I've developed. In these circumstances, the question is whether, objectively speaking, the parties' intentions took a new turn at some stage, such that the parties intended to be bound by the final draft contract without the need for its formal execution. There is no evidence that the parties' intentions took a new turn. Indeed, the evidence clearly shows that at all material times the parties intended that the final draft contract would not take effect until it was signed. And that was a position that was agreed by RTS. So it's got nothing to do with them being prejudiced. They took a decision that on their evidence and our evidence, rightly, there was no change of intention. It was their case. It was subject to contract. The problem is they missed the effect of that when one looked at it as a composite whole and looked at the wording that was actually used in clause 48.
But bearing in mind that it was your case, that, or at least one of your cases, that it was subject to the conditions, why are all these volte-face relevant? At the end of the day, hasn't the court got to make up its mind, since it's largely objective?
My lord, it does, but your lordships, in the discussions your lordships had with myself yesterday, were positing a change of case or something happening after the 5th of July.
Yeah.
The actual case run by both parties, nothing changed after the 5th of July.
But so maybe you're both wrong.
Maybe we're both wrong, my lord. But that has dangers in itself for both parties, because on the facts, what happened, we know, is that both parties didn't follow some of the terms of the contract, particularly in relation to the variation. So if your lordships are, and I'm not seeking to dissuade your lordships from my alternative case on MF1, I'm trying to indicate to your lordships that the 5th of July was a key date for both parties, presumably on instructions, so that when your lordships are deciding, if your lordships are in favour of our alternative case, 5th of July really is the key date. And I'm also trying to say to your lordships that there was no merit in the suggestion that this was raised by the first time by us, because as my Lord Carr pointed out yesterday, it was the result of the judge accepting the submissions by my learned friend, Mr. McLean, that one gets to the conclusion that clause 48 effectively leads to a subject contract case, and it was never changed. It's because the parties agreed it didn't change.
But it's all rather odd, because a lot of reliance was placed on Lord Justice Staines' powerful dicta to the effect that where a contract's been performed, a court pretty reluctant to conclude there isn't a contract at all, which necessarily postulates us looking at matters subsequent to the 5th of July.
My lord, no, that's the point. And perhaps I can go on to the fact.
Yeah.
The case that was then advanced by Müller and Friends was 29th of June. The case that the judge has accepted is that by at the latest the 29th of June, the contract was formed. So any
But it wasn't performed by then. It was performed, we know, 5th of September onwards.
But if it's acceptance by conduct, the conduct that accepts the offer, however one dresses it up, would have to have occurred prior to 29th of June, or on the 29th of June, in order to have a contract at that date.
But why do you need a contract at that date? I mean, you say that parties have pinned themselves to that date, but at the moment I can't see why it's particularly important that the contract should have been in existence or not at that date.
It becomes important, my lord, because as your lordships have seen, subsequently the parties have got into a major dispute about what actually happened and what their rights and entitlements are in relation to the performance of the goods. Now, depending on the date your lordships pick for a contract, if it's a contract, it then may affect what has gone before. So if one, for example, if one assumes that a contract was formed at the time of, in November, which I think, by that stage, the parties have already made major changes to the contract. They have not signed the contract they entered into. They have not followed the change procedure, although there is a variation that everyone agrees was made. And the real question is whether what has then happened is referable back to an original contract which people have not necessarily been following, or it is now by reference to a new contract which says actually for all purposes, either going forward or now, there is a contract which does not take account of what has occurred.
But I don't see that as a particular problem, because it's surely quite possible conceptually for people who've actually failed to finalise a contract in May, but by the 5th of July, but who've actually agreed it later to conduct themselves in such a way that they're committed to the contract which they would have entered into if only they'd actually formally executed the documentation on the 5th of July. Any subsequent events fall to be assessed according to their own merits in the light of an assumption that they actually had contracted on the 5th of July, so that subsequent events in September may constitute a variation or a waiver of particular terms of that contract. But isn't that is conceptually quite possible?
Conceptually, absolutely. And it's that's why we've said.
I can take your point that one were very reluctant to just say, right, well, in November they entered into a contract as if it was the first contract and now being entered into, although it was quite unrealistic because there have been a lot of variations.
And there is another principle, which again, I'm conscious that I'm not trying to persuade your lordships away from my own case. But this is an issue that comes up time and time again in my particular field, which is the construction industry. It's very often, you'll see from the cases, they're mainly construction cases, where parties enter into letters of intent or enter into form without actually having finalised documents. And I would like to take your lordships, not necessarily for persuasive authority, but to look at the problems that are faced by the judges on the ground in dealing with these sorts of problems. And what underlies, as I understand it, the force that is normally given to subject contract clauses, or clauses as here where it's saying that the contract will not come into effect until it's assembled and checked and signed, is really for two reasons. One is that it allows the parties to see the whole contract and make sure that they are happy with the whole and to resile from it if they wish. Second is that people require certainty in their relations, and if you have a clause like this, then they're entitled, on the authorities at present, to proceed on the basis that it will have the effect that it says. Namely,
I suppose if you want certainty, the thing to is to not start the work until you've got some clear basis, contractual basis. So maybe that's the line that should be the message. If you don't, you're bound to have...
if I had had £1 for every time I have said that to a client, I would be a very wealthy man indeed. The problem is people don't do that in the real world because developments are undertaken under pressure, because there are other factors. Very often in complex developments you may have more than one contractor on the site, particularly in the light of the development of now
All that's
modern
true,
contracting techniques.
All that's true.
But the point
Whether
about-
that leads to the conclusion that we should readily say, well, subject to contract continues on, notwithstanding the fact that very, very large amounts of work are done, is a sensible way forward for the future. Seems to me to be very questionable.
My Lord, as I said to your Lordships, I'm not necessarily trying to dissuade your Lordships from that course. There are two questions. On the facts of this case, is that the right conclusion? Generally, if your Lordships, as I apprehend your Lordships will, are going to give guidance for the future, there are issues that have to be addressed. One of them is that it is the unique nature of construction projects and shipping construction projects, I suspect, is that one has activities going on in parallel. So one has an interaction between different parties, employer and contractor, very often subcontractors, here a third party. And things readily go wrong. That's why we have all these construction disputes. If the protection of a subject contract clause is to allow a party to know that they're not bound until they sign, if that is the effect of the law, then it also allows them to take advantage of, just as happened here, where there is a debate about who is responsible, where there has been a problem, and in November of 2005, the parties turn around and say, well, actually, I'm not signing that contract until we have a side agreement setting out what has actually happened and what variations should be agreed to have occurred to the contract. Because they're then able to regulate and protect their position in the light of what actually happens. And if the court simply finds a contract saying, those are the terms, without respecting the fact that the parties may actually have good commercial reasons for not signing up, then one also creates problems. And it's the danger with an undue focus with respect simply on performance. Mere performance cannot be enough if you're simply performing what you anticipate you may sign up to. Because if the subject contract clause applies, all you're doing is saying, I'm going to perform, because I'm assuming at some stage in the future, I will be bound by this contract, and I don't want to be in breach of it. But if you don't sign it, there's then a separate question as to what the legal relationship is. Now, from my client's perspective, on the facts of this case, it doesn't matter in many ways, whether it's a quantum merit or whether it is an MF1 terms. But it is important, in my respectful submission, that your Lordships look at how the case was put in deciding this case, whichever way your Lordships go, as well as in the, I'll try and almost not like Micah's, but try and identify the way some of the construction judges have grappled with this problem. And it has been to give effect to these clauses, generally, on the very grounds that I have identified. Now, your Lordships may well argue that isn't a sensible way forward for the future, and I'm sure we'd welcome that guidance. But the purpose...
If the court were to hold, on this case, notwithstanding what you've just been saying, that a contract did come into existence, say on the 5th of July, then obviously there are a number of questions as to what the effect of what happened later would have or has. Now, those are not questions which we're directly grappling with, are we?
No. And your Lordship
so if we were to hold that on the 5th of July there was a contract, say on the terms of the contract which was apparently complete with that exchange of emails, then it will be for some future discussion as to whether there was a subsequent waiver, variation, estoppel, or whatever.
Your Lordships will see from the draft order we have put in, the effect of your Lordships holding that would be to put back to the trial judge the rest of what are the preliminary issues, and one would hope they would now just do a liability trial, because of course the preliminary issues would have been answered on the basis of the wrong contract. And that's why it was never a sensible case for a preliminary issue trial with respect. But so if your Lordship absolutely right, that we would go back and your Lordship would say, this is the contract, you go and sort out your problems on that basis. Because your Lordships are not seized with what is the effect of this on testing, for example. Does it make a difference whether there was a variation to the contract that they found or a variation to the MF1 form?
This is a case of extreme facts in a way, because there was nothing left to agree. That's the remarkable feature of this case. And if you have a contract where there's nothing left to agree, and then the parties start to perform, it's very easy for the court to reach the conclusion that they have simply waived the subject contract term, if there was one there, because it's no longer got any purpose. They've agreed everything. The point of a subject contract term is to preserve your position until you've agreed everything. Yeah. So our decision on this case should not be taken as a precedent for a situation where the parties have started to perform, albeit that there are still very significant matters to be resolved. That's, I think, what you're saying.
Yes, my lord. And to have in mind that following the 5th of July, that's when things really started to go wrong, because the free issue equipment should have been delivered by then, should have been delivered in July, and wasn't. And that's what led to the variation. So going beyond 5th of July, if your lordships went for a later date, you potentially affect the way in which the parties will resolve their dispute in the future.
What, a later date than the 5th of July?
Yes. So my lord is absolutely right, that the answer in many ways, and was effectively what was being submitted by Müller and in its alternative case, is if this is not a subject contract case, if there is a way that does not apply, then as at the 5th of July, we were agreed. And the fact that parties were going to go away and put together a document which requires signature is neither here nor there.
Yeah.
And that is the question, effectively, that if your lordships are minded to go for the MF1 form, that is the question your lordships will be addressing and answering. Yes. There was a waiver, or it wasn't a subject contract case.
Yes, well, giving my own current stance, I'm very much in sympathy with the point that was being put to you by Lord Mance. If on the 6th of July there'd suddenly been a bust-up because the guarantee hadn't been signed, I think that anyone who tried to persuade the court that there was a concluded binding contract, notwithstanding that the parties themselves said all we've got to do now is to sign, and Clause 48, would have an uphill struggle. But you would say the minute the parties purport to perform a contract, all the terms of which have been agreed, in that extreme situation, they're plainly indicating that the formality of signature is not of concern to them. The issue then comes in if they're performing in something different from the terms that were agreed.
Then that would be regulated by the contract.
Are they intending to perform the contract but varying it, or are they acting, as it were, almost independently?
Because this really ties in with the way the Court of Appeal approached British Steel, which my submission was right, and it was very much the pragmatic approach that my Lord Mance was identifying in discussion with Mr. McLean, that the relevance of British Steel was that was a case where the performance was taking place while the parties were still negotiating the terms. And it was impossible to say during that period what those terms were going to be. All one could ever say was that anyone performing would only expect to assume the obligations that they would ultimately agree to. In the present case, the performance that the judge and Muller and friends were relying on was absolutely during the period in which we were negotiating the terms, including the MF1 contract. And that was the factors that influenced Mr. Justice Robert Goff in that case, we were saying was similar to the factors here. And perhaps I can go out of turn and just deal with that issue now in core bundle. In the core bundle, in the judgment of the Court of Appeal, in tab 2 at page 22. Paragraph 50, His Lordship was recording the submissions that I was making, which the second sentence in paragraph 50 said, at best, such agreement, together with payment of part of the price identified in the letter of intent, amounted to a request to RTS to carry out the work identified in the agreed specifications, which both parties anticipated would become the subject of a formal contract. And that's absolutely right. Thus, rather than being a case similar to Trentham, where there was no continuing stipulation, which is set out in the preceding paragraph, it was submitted that was similar to the one analysed. It's not that British Steel was binding. And then, critically, the factors which influenced Robert Goff J indicating no contract in that case apply with equal force in the factual matrix of this. And what his lordship then set out from Mr. Justice Robert Goff's decision is the very thing he was addressing in that case. He wanted an if contract. He was attracted to the creation of an if contract during the course of negotiations. And he rejected it on the basis, as set out there, that you couldn't say that there was a contractual relationship at that point, because all you could say was that the parties were negotiating and they would only have entered into a contract on whatever terms they would ultimately agree, including limitations of liability. And that's exactly what was going on our submission in this case, which is clear from paragraph 52. Mr. Catchpole submitted that the way the parties approached the negotiations referring to the MF1 terms as the contract and dealing with that first and then coming on to deal with the schedules demonstrated that first, those terms were essential to the parties, and second, in particular, RTS was insisting on a limitation of liability being incorporated into the MF1 conditions and thus the contract. It could also be seen that Müller had agreed to such limitations. And the problem was the judge had found a contract during the very period that was being negotiated and apparently agreed, which didn't include those. It was thus clear the judge had reached what Robert Goff suggested would be the extraordinary result, which he should not have done. The extraordinary result being you've imputed to the parties an objective intention to contract on terms which they clearly never intended to contract upon.
And all I've put there is the creation of the contract by performance is incompatible with the notion of negotiations.
My lord, exactly. And that was the fundamental problem of the case that Müller advanced.
Can I just go back to this passage that we see cited from Mr. Justice Robert Goff, because I still have a little difficulty with what is meant. It is difficult to infer from the seller acting on that request that he's assuming any responsibility for performance, and then this, except such responsibility. So the judge is there saying you are assuming some responsibility. Is he saying that insofar as there are terms which both the parties have agreed and confidently expect are going to be terms of the contract, though you accept responsibility under those terms, or is this rather loose language and simply saying that the seller is expecting to come under responsibility but is under none?
What I understood this to be saying, my lord, was that his lordship was attracted to the idea because he didn't like the idea of there being no contract. Yes. And he goes on to say that in the circumstances it's a quantum merit. Yes. So he was going for effectively a simple contract which says if you do the work I will pay you. And that would have included unlimited liability, which is the effect of the contract found now. And the reason he rejected that was in this passage by saying if the buyer asks the seller to commence work pending the parties entering into a formal contract, it's difficult to infer from the seller acting on that request that he is assuming any responsibility for his performance, i.e. unlimited liability, except such responsibility as will rest on him under the terms of the contract which both parties confidently anticipate they will enter into. So in other words, if you're negotiating limitations of liability, you can't say the seller has entered into a contract of unlimited liability when he's negotiating.
Yes. But how about terms that are agreed? Is the judge here? It's the except, which seems to be suggesting he is entering into some responsibility on terms, not quantum merit.
My lord, no. With respect, it's because except such responsibility as will rest on him. So it is.
But he's saying he's talking about what responsibility is he assuming by his conduct.
Yes, well,
and so I think I agree with you, but it's loose language, isn't it, to suggest he's assuming any responsibility. Well, counsel has to.
You can agree. It must be that.
Yes.
It could be. Yes. Maybe it should have read except that he's contemplating assuming.
Yes.
But if you look at the earlier bit, it says, when in such a case as the present, the parties are still in a state of negotiation where it's impossible to predicate what liability, if any, will be assumed.
Exactly, my lord.
And then he says, in these circumstances, so I think he's still dealing with the same.
Yes. And he is saying, as a court, you should not step in and just assume there is a contract because of performance. You have to look at what the parties are doing.
The trouble with all this, though, is that the point that troubled Mr. Justice Robert Goff is the point, if you like, that troubles us. The idea that these parties, that the law will require, will reach a result where these parties apparently agreed this sum without any commercial terms at all, seems cloud cuckoo land.
Well, I agree.
And that was one of the reasons which Mr. Justice Robert Goff had at the forefront of his mind in discussing all this. I mean, he was very worried about
And
that.
your lordships will see from
I wonder, actually, whether the whole concept of quantum merit, suppose it is a quantum merit, why can't one import a lot of these terms? Why wouldn't say, if it's a quantum merit, why don't we say it's a quantum merit, but on the terms of the agreed contract?
But your lord, and this is off
Because
the point.
I've been quite interested from the start about the case, about how the liability is for the agreed price. If it's a non-contractual quantum merit case, how does the agreed price come in?
It would be evidence of what would be a reasonable sum for the base scope.
Yes, but that's only on the basis that that was agreed on the basis there'll be lots of terms. So to say it was agreed without any terms is ridiculous, because the parties would never agreed it without any terms. Those are the considerations which make it very difficult to swallow, the result which the Court of Appeal ultimately achieved.
My lord,
That's the long and the short of it. It may be not
a number of
detailed legal
issues.
analysis. But
First, I suspect if you spoke to anyone in the field, they would have the same reaction. I have the same reaction. The reason why parties sit down and negotiate contracts of this type at length and very carefully define what their rights and liabilities are going to be is because it relates to the thing that contractors do best, which is price risk.
Yeah.
Before they enter into a contract, they want to know what their exposure is going to be. And that's why, again, I'm concerned about contracts being entered into by conduct way down the line when things may have changed.
I suppose that banks who are lending them the finance they need are insisting that they should have taken out a performance guarantee of some kind, and that's an element in the price that they are negotiating.
But every contractor,
that
and particularly
performance guaranteeing particular performance of particular terms.
But every contractor in these types of contracts, where you're particularly going into a live factory production line or a live site, is concerned about the overall exposure that they may have. And if you're potentially exposed to unlimited liability, then you could go bust. It's a risk
On your
not worth
primary
taking.
case, that's what's happened here.
On their case, it is what's happened here. Whereas on our case, it's not, whichever route one comes to, either quantum merit or otherwise.
Well, it depends how you look at the quantum merit, I think.
But in answer to my lord's
This might point
there is
about the quantum merit.
a wider debate, because I suspect if this somehow was a tort claim, one would be limiting the duty by reference to what the parties were actually discussing on the time. And one suspects that there is scope in the development of the law of restitution that for similar limitations to be applied. It would make perfect sense.
Perhaps in this very case.
Perhaps in this very
If the
case.
Court of
no.
Appeal position is...
But whatever else, it is fundamental to what contractors do that one has clarity about what exposure you have to liquidated damages, that you have limitations on liabilities, that you have in place a defined obligation in relation to access to site. Those sorts of things are the things that make you determine your price. That is a business.
What is the conceptual basis on which people argue that tort liability is qualified by reference to contractual terms they haven't agreed? I can understand that it might be in some cases there was no duty of care at all, but to qualify it as, I've heard of bailment on terms, I haven't heard of
Quantum merit.
Quantum merit on terms.
No, I don't see what's wrong in principle. This is back to the Ali Akmon.
There is a debate to be had. And if the conclusion was, for example, and not this case, but it was an advice case, where a designer was giving advice in relation to matters where for some reason there was no contract, then one could see the fairly strong argument that one would look at the duty of care to be informed by, if you had the analogous facts, what was effectively agreed by the parties at the time they were giving that advice, because that would shape the duty that they had.
Interesting.
But not this case.
It's not this case.
Well, I don't know about that. I mean, that's why I'm interested in the price, what the status of the agreement about the price is.
Well, the answer is...
What evidence is the agreement about the price? And where is the evidence that the price was agreed untrammelled by any terms?
There isn't any.
Well, the price was
In the letter of intent.
in the letter of intent, which was subject to the MF1 conditions.
Well, the letter of intent wasn't, but it expired, but in the MF1 conditions it identifies...
Well, it's in Schedule 2.
Not quite.
Sorry, no, it's in the definitions.
Not quite. I'm sorry, it's my fault. If your lordship goes to clause...
Well, it's clause 3, isn't it, on the definitions?
My lord, it is, but if your lordship goes to page 1150, clause 11.2, the purchaser shall pay to the contractor the contract price. And the definition defines the contract price as the 1.68. And that was why the contract was a rather bizarre one, for many reasons, because the judge actually excluded the very documents that define the price they'd agreed for the work that was in those specifications.
Those are all good reasons maybe for having these terms, but without the terms, it's very unclear to me what the...
Yes, well, if it was a quantum merit, it would be simply that we would be entitled to a reasonable sum for the services we provided, and that would be determined in the light of all the circumstances, including what we are being requested to provide and what we actually provide. But from my client's perspective, the protection it gave us is effectively, to all intents and purposes, the same as the contract, because there would be no claim for damages for breach, because there would be no contract, and our ultimate liability would be the value, the monies that have been paid already to us that they could claim back. So, which is the same in effect as a limitation on liability equivalent to the contract price.
You were giving us a rather useful trawl through the history of the case. Did you finish that?
No, my lord. Could I just... I will continue, if I may, briefly. If I could go back to some of these away. The fourth volume of Part 2 at tab 80. I just note on page 1320 that the email to which Müller referred, the 13th of May, was the contract that Mr. Morris is referring to had been sent through on the 11th of May, and it is the third version of the MF1 terms with all of the schedules in it, which was then tweaked on the 16th of May. And your lordships have the reference. It's page 1320, yes. Paragraph 65. They rely on Mr. Morris's email of the 13th of May. And if you, lordships, just for your lordships note, tab 39, page 721, and tab 41, page 770, well, the email is literally either side of that, which show that the contract is the whole contract. So that was their case. The one goes forward to...
The whole contract, is that version 4?
Well, perhaps I can just show you, lordship, briefly, it's quicker. It's tab 39 in Part 2, Volume 1. The page 721, this is the 11th of May, this was version 3, and one sees from what follows is it's the entire contract including all the schedules, although the schedules still have to be completed at that stage. Tab 40 is the email which Müller and friends cited in their case and relied on. Not quite plainly, the contract they're referring to is the contract that's just been sent through. And tab 41 is the version 4, to which my Lord Clerk has just referred, which was sent 3 days later with a few tweaks. Again, with all the schedules there.
And so the only change after that was what? The force majeure, was it?
The contract conditions force majeure, which was the 5th of July. What the parties then did, if your lordships have... If your lordships go to page, 45, tab 45 in the next volume, page 822, there was one amendment. Bottom of the page 822, on the 19th of May, Mr. Brown said, "Sorry for delay in responding. Latest draft seems fine except for one issue." And you've said he identifies a deletion. And we've covered that in the draft order. The response is, have you got any comments on my comment? Again, that's sent on the 25th of May. And And Mr. Morris responds on the 25th of May saying, "This is next on the list, your comment below looks fine. So I need to get back to you on force majeure and any final tidies up. I'll get back to you by later on today." The key thing is then that they, 825, let's deal with it, it's on tab 46. Following day, Mr. Morris came back saying, various amendments accepted. He's still got a problem with force majeure, and then I'm meeting with David and Mick tomorrow to go through where we are on the schedules. I've been through the contract, a couple of incorrect cross-references, but nothing material, and that may be, one doesn't know, maybe the reference to Schedule 7, for example. I suggest I forward this to you tomorrow when I have an up-to-date picture where we are on other elements. And then 8:30, the same day, is the email your lordships have already seen, the 26th of May, which is our understanding, which is what the judge and Müller were relying on, as evidencing agreement to certain of these. Our understanding of the current status of the contract schedules is as follows. So it's quite plain that what was being contemplated at all times was that the contract schedules should be schedules to the contract, not freestanding contractual documents. The Lords, going back to Müller and Friends case at trial, if one goes back to volume 4 of part 2, page 1321, paragraph 70, they set out the contract based on the schedules. They then set out the schedules that they particularly are interested in, and then say at 70, the URS in particular was to have had considerable significance under the final draft contract when executed. And they set it out, then they set out the terms in 71 of the FDS URS. They were agreed by 29th June at latest. 72, consequently, by 29th June 2005 at the latest, the parties were ad idem as to the critical documents that defined RTS's performance obligations. It's not a case where a transaction remained executory, common ground that they paid, and if one goes on, that is what they then say is the contract that formed the basis of the judge's finding. So they were saying that really by that stage the contract was formed. And it's one of the problems with, as I say, the performance, simple focus on the performance requirement, that it leads to, with respect, not some loose thinking, which I'll show your lordships. So again, repeated refrain in the courts below. So if your lordships are giving guidance on it, it would help, because what happens is there is generally, as here, an assertion, because there has been performance, therefore must be a contract. Which bits have they agreed? And that is not the test. It's certainly not what Percy Trentham requires. And the real risk is the court starts to impose agreements that the parties haven't reached. And that is exactly what, in my submission, the court shouldn't. The RTS written opening, just a similar effect.
Well, the question is whether the parties must be taken objectively to have reached the agreements on the facts of this particular case. I quite take your point that one should be careful about saying that mere performance leads to a contract full stop and so on.
Well,
it all depends upon the facts of the particular case. And the striking thing here, as my lord put it earlier, is that there was nothing further to agree.
I agree. I agree with you, Roger. Entirely agree. And I was, my lord put it to me, I was constrained by their case and what the judge found. The problem was their case actually proves exactly the contrary of what they believe it proves.
I mean, the points they're putting in these paragraphs here, how does that fit in with their subject to contract case?
I don't know, my lord. That is the problem with this case. That at all times they are saying all of these documents are subject to contract. That was and is their case. And it is remarkable that the suggestion is our case, because it's not, and yet they pick documents from it. And the danger, as I come back to the danger of just focusing on what Lord Justice Steyn said, is that one runs into the problem with respect to my learned friend that he had trying to answer questions about, well, what is the basis on why you pick these documents? There isn't one. Other than one starts from the proposition, there must be a contract, now let's find one.
But I think the rationale, such as it is paragraph 72. These are the critical documents defining RTS's performance obligations.
So one ignores all commercial terms.
Well, that may be the criticism, but I mean, what they put together two things. Firstly, performance, and secondly, documents defining on performance obligations.
Even as stated, my lord, that is untrue. Because what defines the performance obligations are the MF1 terms. They set out the duties that we have, they set out the warranties we give, they set out the obligation to do the tests, they set out what liability we will have as a consequence of a performance obligation with a limit.
Yes,
so you can't...
I know the argument, and I see it, and it does actually depend upon matters subsequent to the 29th of June, doesn't it, their case?
But they don't plead anything.
Well, paragraph 73, they rely on performance.
Which the simple fact that it was performed. Now, to take the logic of that as a case, nothing new has happened, no waiver of the subject to contract provisions. It is the mere fact that the parties continue to do what they have been doing since the letter of intent back in February, i.e. working to the specifications that are in draft. That's all they are doing. There's no change in position. They're working at best towards something that they are anticipating still will be signed in the future.
I think that's a bit of a gloss, if I may say so. I mean, actually, to arrange to deliver and to deliver a line, a production line, is a rather different thing from working towards contracting to deliver a production line.
For that reason, my lord, and my lord, as I keep saying, I'm in a slightly odd position because I absolutely agree with your lordships that the logic tells you in cases of this type one ought to have the very terms they've actually agreed and clearly intended to put into effect. And your lordships will see on the evidence, absolutely crystal clear, both sides, common ground, the only intention was to contract on an MF1 form.
And
there's no debate about it.
The only point against that in this argument here is on paragraph 68 on page 14.
Well, my lord,
because the reasoning here is it's all subject to contract, never stopped being subject to contract. They didn't act on the contract itself because they did something different. However, they did act on the schedules, and therefore they are the contract.
but that, my lord, with greatest respect...
I'm not suggesting that's right, but that's the argument.
That's what I was saying before. 68, an engineer was not appointed. Well, the engineer does not have to be appointed. I've shown your lordships the definition of engineer in the MF1 terms. By default, the purchaser is the engineer. So if there's not one appointed, the contract works. We didn't provide... payments were made by Müller to RTS in the amount specified in the MF1 terms. What we didn't provide was the advance payment guarantee. It was only at the end of the project where the percentages changed because we'd only delivered one line. So instead of getting 20%, they only paid us 10%. And then without RTS providing certificates of payment, so this is now saying that because RTS have decided not to give a certificate, somehow or other, that wipes out the entirety of the MF1 form. Well, that's absurd, with respect. All that would mean is they're in breach and we accepted it because they gave us some money. And none of that has any force at all.
What, if any, relevance is there in the reasons why the parties didn't in fact sign the contract? They reach agreement, you look at the exchanges, it looks as if the only thing left to do is to sign the contract. There's no suggestion there's going to be somebody poring over it in some office or anything. They've negotiated it all, but they didn't sign it for some reason. Now, if the question is whether there was a binding contract on the 5th of July, I suppose one might say the reasons why they didn't sign it subsequently are irrelevant. But I wonder if that may be too stark a view, because it may be possible to use that evidence as relevant to the question of whether they did enter into legal relations on the 5th of July.
The evidence was, I think, fairly neutral that they got on with the project. And there wasn't a particular reason until a problem became apparent, at which point Mr. Brown said in November, there is no, it was agreed in principle, your lordships have seen the reference in the judgment, it was agreed in principle, never formally executed, and we're not going to sign anything until we get a side letter bringing us up to date.
So the facts are then that they make the agreement, apparently, all the terms are agreed, on your analysis at least, they get on with the project, presumably on the basis of those terms, in effect. And they're essentially operating the terms, until something goes wrong months later, when one side or the other says,
not months later, during July, there is a debate between parties, but during July, as I understand the case, RTS say that the free issue equipment was not delivered in accordance with the obligations of Müller. The result of that was that Müller needed to get additional production. They had a contract with Tesco, and they needed a certain level of production. I can't be reminded of the figures. 150,000 units.
Yeah.
And that required putting line 1 into operation. Line 1 had originally been intended to be the second line to be put into operation. The consequence of the variation was that line 1 was going to be put into operation first, that instead of doing customer factory tests integrating the free issue equipment with our equipment at RTS's factory, we just delivered everything to site, and the integration was going to take place at RTS's premises. And there was then a debate about what obligations we had to do the site testing, and whether or not we were prevented from doing that, which is not something your lordships need to be concerned about. But there is a debate about whether, in effect, what Müller did was say, we just need the production, thanks very much, we'll have the line, run it to meet their contractual requirement for Tesco. So from very shortly after the 5th of July, things start to change dramatically on the project. And that is the problem with the later contract. So if I go back to what I was submitting to your lordships before, assume a case where that had become apparent that the specification was now being wholly rewritten by Müller. I'm not suggesting that is this case. And that became apparent on the 16th of July. Now, if the subject contract clause has the effect that the authorities say it has, then my clients would have been entitled to say there's no contract, we're not going to enter into anything, we are protected. There's going to be no debate, there is no contract. Equally, Müller could say, there's no contract, we're now going to change everything. And there would then be a large commercial negotiation. If your lordships, however, hold that because they were going to put in together a composite agreement, there was going to be a period during which the clause 48 had some effect, then potentially people are bound to a contract that they could have got out of on the basis of your lordship's determination of whatever a reasonable time is for the effect of that clause, when the parties themselves would never have known that on the ground. So they could potentially be bound to a contract at a point which they could never have reasonably determined themselves. And that's why one needs this certainty because it does affect the way parties behave. And if the certainty is we don't have a contract, if Mr. Brown's evidence, rightly or wrongly, if you look at my great if you've got the bundle of documents, the witness statements, behind tab 5 is Mr. Brown's witness statement. This is pleaded, and if one looks at paragraph 51, that gives you a flavour of what I'm sure this will be in dispute, but it was what RTS is saying that the judge is going to have to grapple with. Pleading, our contractual statement case is paragraph 40.3, tab 11, page 219. But effectively, the contract had gone wrong very shortly after the 5th of July. On
your analysis, there is a sequencing issue here, isn't there? First of all, agreement, and then performance. And it's only at the point of performance after agreement that the contract comes into existence.
Well, it depends on how the case was put. That's why it's so important that on the facts of this case, the case, as I understand it, that was put, was that the agreement was actually reached by, at the latest, 29th of June.
Yes, well, that may be
the mere
the case.
fact that we are continuing to perform, so day one, as soon as we start to continue to perform, that is the obligation.
Right. But have we seen material which persuades us that there was performance sufficient to activate the agreement before things started to go wrong?
That there is no dispute between the parties that we had started to perform. It is that in the period leading up to the 5th of July, the performance was at our premises, because the intention was for us to develop our equipment. The free issue material would then be provided to us at our premises, integrated, tested at our premises, then transported to Müller's premises, installed, commissioned and tested there.
So the performance could have taken place before the 5th of July?
It did take place.
Did it?
It was taking place. That is the problem. The only performance they're relying on is exactly the same performance that was going on before.
Well, it depends what you mean by performance. In theory, a seller who, in reality, might spend months preparing a line of goods isn't obliged to do anything until 1 minute before the delivery date. If he can deploy 1,000 people and spend £100 million, he might be able to do it in 1 hour. You say it was performance, and no doubt things were happening, but were they contractual? In other words, was there actually a contractual obligation for you to test or to reach any particular stage of preparation in June?
No, but they had paid us 30% of the price in April. Which is
That's slightly different.
Leave aside what the Appellant's case is here. Your analysis of your secondary argument, as I've understood it, has been that you have to have agreement, which you say was concluded on the 5th of July, and you have to have performance. On your analysis, I appreciate that this is your secondary case, when did that performance take place?
2 points, my lord. One is, if your lordships conclude, as I think my learned friend is submitting, that clause 48 doesn't, and on the evidence this is not a subject to contract case, then it's not a performance case, it's simply an agreement case, and 5th of July is the point in time.
Right.
So that's the primary case that I adopt. My difficulty is that I am not skilled enough to see how one gets around clause 48 in those circumstances, because clause 48 seems to me to have a plain meaning. But if your lordships hold that it doesn't have the meaning I contend for, and contended for in the Court of Appeal, then the answer is straightforward. Performance, if a contract is simply performed by the parties doing what they anticipated they will always do, then at the point at which they've reached sufficient agreement, which is 5th of July, the contract comes into place, because my clients were performing according to the specs that were being drawn up. I don't think there's any doubt about that, and I don't believe it's... No, Miller and Friends says that it is agreed that we are doing, it was necessary under the original programme. It's the point about the programme. The original programme is anticipating delivery dates of free issue equipment earlier than actually occurred. So we were doing it. So performance doesn't become an issue if that is the test. And that's a matter, if your lordships accept that, then 5th of July is the point at which, on this case, there is a complete contract, precisely because, as my Lord Phillips has put to me quite rightly, it's an exceptional case in that the parties had agreed everything, with 1 or 2 exceptions, which are potentially the Schedule 6, depending on the view your lordships take of Schedule 6. My Lord, while I've got the witness statements open, could I just show your lordships also two further passages. The first is in tab 2, at page 36, paragraph 35.3. This is the witness statement of Mr. Miller. Sorry, it's not Mr. Miller at all, it's Mr. Morris. The name I always have difficulty with is the solicitor for Müller, for what it is worth. He is dealing with the evidence following the 5th of July email, which he deals with in paragraph 32.
Sorry, where is this, please?
Sorry, it's page 35 and 36. Paragraph 32 deals with the email and just recounts what is set out in the email. And then in 35.3, it says final agreement and collation of outstanding technical schedules. One colour copy of the contract conditions was then printed. The background draft removed together with the schedules. The purpose was for Mick St John to then have a final run-through of the entire document with RTS prior to signature. Now, that never occurred. And if your lordships go forward to tab 5, page 46, the passage in Mr. Brown's evidence, Mr. Brown of RTS, it's cited by the judge, I think in paragraph 68.
Sorry, which paragraph was the final run-through paragraph?
It's 35.3, my lord, on page 36.
Thank you.
And paragraph 46, on page 46, this is cited by the judge. My intention was then to read through the document from cover to cover to ensure that it was in line with my discussions and agreements made with Will Morris, and then sign it. My view was that whilst we had agreed the wording in principle, until the whole contract, including the schedules, had been compiled as a complete document and signed as accepted by RTS, then it wasn't enforceable.
Right, which paragraph was that?
Paragraph 46. Whether this is right or not, I don't know, but that's what I thought then. So I appreciate both of these are subjective evidence. And it's right I draw your lordship's attention to them because that is what the parties thought at the time.
Well, the shorthand writers this morning must have been writing down an enormous amount of discussion, which I hope will be of value in the future, but we'll give them a break now.
Yes, sir.
All rise.
Well, so I briefly just complete how the case was opened below, so your lordships can see the respective positions of the parties.
Just before you do that, could I just ask you about what happened in July? Am I right in thinking that when this problem in July arose, that the parties did then reach agreement as to what was to happen?
That's the variation.
So that there was, in fact, a variation, if there was a contract, at any rate in this connection.
There was a variation. A point run against me is that there was, and I think by the judge, was that the variation provision and the dispute resolution provision was not operated. So in August, when they did vary it, they didn't follow the exact procedure.
Maybe, but it's not in dispute that there was a variation.
No.
If there was a contract, that there was a variation at any rate to that extent.
Yes, the only question would then be...
Well, lots of people vary contracts in a non-contractual way.
I mean,
Indeed, that's the whole point of a variation.
They came very close to it. I read the variation procedure. I mean, it's not... I'm not quite sure in which respects they fell short. There wasn't an engineer, of course, but...
My lord, I agree. The only question then becomes what the effect is of the variation under the terms of the contract. The preliminary issues, but that's for the trial judge to determine if your lordships accept an MF1 contract.
But nobody at that time was saying, oh, well, there's no contract, so there's nothing to vary.
At that time, I don't think the...
It wasn't until November that the points were taken on
Exactly.
whether there was a contract.
So going back to the point earlier about what the parties were actually doing after the 5th of July, the fact is that they were performing it. Nobody actually signed on the dotted line. When they did have a problem, it's true that they had a problem. When they did have a problem, they resolved it by something close to, but not precisely the same as, the contractual variation mechanism. And it was only really in November that some bright spark said, oh, no, by the way, we haven't got a contract at all.
Well, it was more important than that. What was being suggested wasn't right. What happened was that Müller sent the terms and conditions through, and RTS said, no, we want a side agreement before we sign, to reflect what has actually happened. That was the November.
In November, yeah.
Yeah. But my lord, can I come back? And I am in a slightly odd position here. My submission effectively is for certainty. Now, if one goes back to, if I start again, sorry. Your lordships, I apprehend, will give very valuable guidance on how contracts ought to be formed. The submission I make is my learned friend elevates Lord Staines's judgment to a position that he never intended it to have. It's a simple, straightforward statement that if you have performed, it may be more difficult to do the following. It was never intended, and expressly not intended, to deal with a case where there is a continuing stipulation that you need a formal contract. He says this isn't this case. My understanding of the law of contract is that there are a variety of tools that the courts have used to answer the central question, which is identified by Lord Stein, of what the beliefs are of reasonable, honest commercial men, whether objectively they've reached intention, or in Lord Bingham's words in Panyan, that the central question for the court is to determine what objectively they have agreed, if anything. And those tools may overlap, but they are offer and acceptance. Is there a consensus item? Is there an intention to create legal relations? Has there been some unequivocal conduct that shows agreement? But what it is aimed at is a point at which one can say with certainty that whatever it is proposed has been accepted and they are agreed. The difficulty with a performance-based acceptance, as in the present case, is what is suggested, what is disguised by the approach adopted by my learned friends, is to say, well, there's performance, therefore there must be a contract. That isn't the test. The question is, was there an agreement to contract on the basis of whatever they are proposing as the contract? And that's why the courts, in my submission, have always required clear and unequivocal agreement that so you can identify what it is the party is supposed to be signing up to and then performing according to it. But all of those are really ways of trying to grapple with, as Mr. Justice Bingham, as he then was, said in Panyan, the very fact is that every contract is different and it's on the facts. So it's easy to say in the present case, of course there was an intention to create legal relations. The question, as Lord Justice Waller determined, was there an intention to create legal relations on the contract the judge and Müller found, or was there an intention to create legal relations as a contractor? Then there's a question, did they actually arrive at it? But the simple question, did they intend to create legal relations, doesn't help, because clearly both parties wanted to contract. The obstacle is the subject contract point. Once that falls, then there is clear agreement between the parties. But it can't fall simply because they have performed according to the contract they think they are going to enter into. Because that creates uncertainty for people on the ground. If they're proceeding on the basis it's not binding until they've signed, but the court says, well, actually, after a reasonable period, if you perform with a subject contract period clause, you are bound, at what point does the project manager know that there is a binding contract? And that's really the practical problem that I'm inviting your lordships to grapple with in giving guidance. It's not simply enough, it's easy when one is here to say, looking retrospectively, well, actually, there, on this case, it happens. When you've got someone who, in a multi-party contract, has got various contractors who have not signed on the dotted line, and things are going wrong, at what point can he turn around and say, no, you are now bound and you're repudiating, and not run the risk that he's done something improper in saying that?
Well, the moral of the story is quite clear. Never do anything until you've agreed the basis on which you're doing it.
Exactly.
And that's what they did here, initially.
Exactly.
So maybe, unfortunately, the parties, it seems to be common ground that the letter of intent contract didn't continue.
No, well, it's common ground because the judge found it.
Yes.
Anyway, my lords.
Can you just help me on one point, just jogging back slightly? The actual programme, which was to be Schedule 10, became some plans which we don't actually have, do we? The judge said the programme was overtaken by the overall project plan and the installation at Müller plan referred to in paragraph 52 below, and that's the document sent on the 29th of June, but it's the one, we don't actually have them.
My lord, no, I believe it's a substantial.
Yes, I mean, it just, it might just bear on what was being discussed before the adjournment, whether your clients were actually contractually obliged to do anything by way of performance at any relevant time.
The approved programme is there, but not the subsequent one, my lord. Your lordship has the approved programme, not the approved. The approved programme produced by Mr. Brown, the earlier programme.
Yes, so we don't have the actual one.
Second one, no.
So, well, it might be of interest to look at, but
if your lordship would like to,
it's a huge document.
I'm sure we can get a copy, my lord. It is quite a, if your lordships would like it. Could I just show your lordships briefly, again, tab, this is the fourth bundle of part 2 of the appendix, tab 79, page 1299, this is in RTS, RTS's opening skeleton argument. Paragraph 117 sets out primary case that they don't accept that any contract was agreed after the letter of intent. First point was it was never signed. So there was, in effect, common ground in relation to that before the judge. Then the second point, the judge decided against us, in effect, saying that these weren't material, and that's not an appeal. Thirdly, again, that was an issue that decided against us. 118, the alternative case, if there was any contract, then it would be on the basis of the MF1 terms. So again, all in issue for the judge. If one then puts away that bundle and goes to volume 5 of the part 2, which has the transcripts, only RTS gave an oral opening, and that starts in tab 84. Mr. Manzoni, then representing the RTS is used now.
Sorry, tab?
Tab 84, my lord. Page 94. Line 14. Mr. Manzoni says, so, my lord, what we say that Müller are seeking to do is essentially cherry-pick the documents. These documents are being agreed as one goes through. They're being produced as one goes through. We say for the purposes of identifying the schedules to perform part of the intended contract, which neither party is contending would become binding until signed, but never was signed. My learned friend is nevertheless saying, despite that was the intention of the parties, that this secondary contract, if I can call it that, wouldn't become binding until it was signed. They picked the date of the 29th of June to say, well, enough at that stage was agreed. Consequently, they pick that date as being the date when the contract came into existence, relying only upon those limited documents as being contract documents. As to that, what we say is we don't accept, for the reasons I've already identified, that there was actually an agreement as to the contract, but if there was any agreement, then inevitably it's based upon the MF1 standard terms as amended and essentially agreed between the parties. And he goes on missing down to line 12. We say, in fact, it never happened. Whatever the position is, we say you can't just cherry pick, as Müller are seeking to do, the documents which they want and seek to exclude the documents which they don't. They clearly don't want the standard terms to be in there because there are some fairly strict restrictions on liability and damages arising from those standard terms. There are 2 liquidated damages clauses, in particular one for late delivery, which limits it to 2.5% of the contract, and one for lack of performance, which limits it also to 2.5% of the contract price. Müller is seeking to claim about 5 times the contract price in damages. We suggest they're trying to exclude those. So it couldn't be plainer that the issues that your Lordship are dealing with...
There's also quite an interesting exchange on pages 96 and 97 of Manzoni and the judge about, well, and this is a point that I think I'm the only person who's worried about this, is where you get the agreement of the price on these various analyses.
Yes.
And the point I've been making is one that's actually made by Mr. Manzoni.
Exactly right.
96, lines 19 to 21.
Exactly right.
And then the judge explained why there had to be a contract in 96, 97. The only question is what objectively it was.
And, well, then he goes on, my Lord. See, if your Lordship goes on at page 98, from line 5, so the relations dealt with documents being discussed in negotiations, we say if you are to construe any contract arising after the letter of intent, which is separate to or in addition to the letter of intent, effectively you have to do it by reference to all of the documents which are agreed, not just some of them. And one of the documents which was agreed was the draft terms, and Mr. Justice Christopher Clark said, yes, you joined forces with Müller in agreeing that everybody reckoned the deal wasn't over and hadn't been made until it was signed because, and you say it's all I's and T's weren't dotted and crossed and therefore there was no deal, even though it was very close. And then he's missing a line. If you're wrong on that, then you say whatever contract one might construe is to be based on the MF1 or whatever. And Mr. Manzoni said, it does, my Lord. If the parties have reached an agreement as to any aspect of the contract, then certainly the one document they've agreed are those commercial terms. The judge says that's got to come in somehow. That's got to come in. I see whatever permutation you choose, if we get to this aspect, MF1 features. That's what you say. Yes, that's right, my Lord. My learned friend doesn't accept that. He picks a later date. He ignores what we say on the face of the emails was essentially an agreed document, MF1 back in day. He picks 29th of June as being the applicable date. He cherry picks the documents. Essentially, that's the difference between us. And then one goes forward to page 102. Still in the argument of Mr. Manzoni. Line 3, Mr. Manzoni, whatever happens, if there is an agreement, it is clearly predicated upon the MF1 terms and includes as those terms essentially as agreed between the parties. The judge, the other logical possibility is that the letter of intent agreement came to an end at the end of May, or whatever the agreement date which was extended. There was no agreement, and you're entitled to a quantum merit. Mr. Manzoni, we've pleaded that too, my Lord. Mr. Justice Christopher Clark, but with the added advantage of no excluding clauses. Mr. Manzoni, no exclusion clauses and no specification either. So there it is. So absolutely, there's no question that these issues were before the court. And my learned friends keep saying they were. No question that they were there. Pleaded, raised specifically, dealt with by the judge, and it becomes even more apparent in the debate with my learned friend in closing, because one goes to the closing submissions at tab 86, page 36. It's the start of my learned friend's submissions to the judge. Line 22. this is going back. This is the overall programme. I believe Prince & Masons have copies, which they will hand up, my lord, in due course. So your lordships will have the overall programme in a moment. The lines on page 37, lines 5 and 6, my learned friend identified the question. Second, did the parties enter into a subsequent contract? And if so, on what terms? So he's identifying the very question, was there a contract? And if there was, what are the terms? One then goes forward, albeit to page 41, and I stressed that this is in the context of the discussions over the letter of intent. It is, so it's at an earlier, so it's not in relation to the June-July period. But at line 19, my learned friend says, in relation to the letter of intent, the subparagraph Roman 3 is in the letter of intent, that Müller is not content to enter into simply the terms which are set out in the quotation. Müller wants to enter into an amended form of MF1 contract in a form which is yet to be agreed. That amended form of contract will contain the full terms, and it will contain the relevant technical specifications which have yet to be finalised and agreed, i.e. the ones that he then takes out of the context of the contract at a subsequent stage. And he, going over the page, says, page 42, line 8, first of all, that the terms are going to be based on Müller's amended MF1 terms. And line 21, my lord, we say that during the period of contemplated negotiation, each party obviously retained the right to object to what the other parties might propose in terms of contractual terms and in terms of performance specifications. There's no guarantee at the end of this 4-week period, that's why he's dealing with letter of intent, that the parties would be in a position to agree. They might, for example, be unable to agree the precise terms, etc. And then one goes forward to page 77, where Mr. Justice Christopher Clark raises specifically the subject contract point. At line 20, Mr. McLean said, your lordship then says, or one asked rhetorically, well, what about the MF1 terms, which got close but not close enough? We say that the evidence demonstrates that at no time did the parties intend to conclude a contract based on those full terms and conditions until they were signed.
I'm sorry, which page are you on?
Page 77, line 19. And we get that from a number of places, my lord. First of all, that is what is contemplated by the letter of intent, subparagraph 3, contemplates that these terms will be signed, the judge not sees it, and in effect the discussion and negotiation of these terms proceeded on a subject contract basis throughout. That was the understanding of the chief negotiator for RTS, Mr. Brown. He says effectively in paragraph 46 of his witness statement, that's what the judge cites in the passage I've shown your lordship. Then one gets the evidence that it's not binding until it is signed. That's clause 48. Mr. Justice Christopher Clark, what he actually says is something slightly different. What he says at paragraph 46 is, my view is that while we had agreed the wording in principle until the whole contract, is not clause 48, he's referring to Mr. Brown's witness statement, including the schedules, had been compiled as a complete document and signed as accepted by RTS, and it was not enforceable. So what he is saying, is he not, we were never going to agree to the Müller terms until they'd been signed up. What he appears to be saying is we were never going to agree to any contract until we had signed up the Müller terms, the schedule, Uncle Tom Cobley and all. Mr. McLean, yes. So it's a composite whole argument being put. Mr. Justice Christopher Clark, if the position was that the parties were proceeding on a subject contract basis, my learned friend's case, that might cause one to think that it's not to be imputed to them that they have made a contract upon the footing of any of their documents, even if agreed, until they have agreed all of them. And although the letter of intent has either terminated in accordance with its terms, or they have agreed that it shall terminate, it doesn't matter which, that when in fact things don't come to an end, and they continue without having made any specific agreement, that the inference to be imputed to them, say, contract on the terms of the description of the project contained in the quotation referred to in the letter of intent. Mr. McLean, one can postulate that as an inference, I accept that. But when one looks at what actually happened in relation to this, we suggest, on the evidence, that isn't the conclusion that your lordship is required to reach because of the agreement of the parties on 29th June to substantially to all important technical documents for this project, when considers that we have this sort of curious period, things go quiet on the terms of the contract after July, and then he goes off into the fact. He never actually explains until one gets to the 81 line. In that context, one has the evidence the important technical documents have been agreed. project is proceeding, and we say the only reasonable inference that you derive from this is that the parties were conducting themselves on the basis they were committed to each other on this project on the basis of the underlying technical documents. So the parties' contact from the end of June effectively demonstrates in our submission that the parties were content to proceed with this project without the full draft terms and conditions. So it is simply a case of the mere fact you have performed what was contemplated gives rise to the documents he's cherry-picked at a time when the negotiations are ongoing. But whatever else is clear, the very issues which are being canvassed before your lordships were expressly an issue at the first instance trial because it was my learned friend's case. And it makes their case before your lordships, in my respectful submission, remarkable. It also illustrates the fact that both parties' subject contract case was being run by my learned friend and was accepted by the judge. And if your lordship looks at tab 4 of volume 1, the judgment again, paragraph 67, page 56. The second sentence. This was, he's setting out my learned friend's submissions. Müller submits that, and then this was because it was the parties' intention that detailed terms negotiated by them would not have contractual effect until the documentation, i.e. the contract and the accompanying schedules, was formally executed and signed. This is recording the submissions your lordships have just seen, and his conclusion came at paragraph 77. I hold, therefore, that by no later than the 29th of June 2005, the contract between the parties, which was to apply retrospectively, was that RTS was to provide the goods and services. So he is saying, as at that date, it is concluded. And my lords, while I've got that page open, perhaps I can just reiterate some submissions I made earlier. I hope we're not repeating them. If one looks at the reasoning of the judge and why the argument developed in the way it did in the Court of Appeal, he's accepted my learned friend's submissions. One can go through them, starting with 76, clause 48. I've already made submissions about the fact that they misconstrued it. That's a complete answer. And my learned friend recognised that in the Court of Appeal, and that's what Lord Justice Waller was referring to when he set out paragraph 79 of my learned friend's skeleton, where they suddenly changed tack and went for clause 48 somehow precluded an agreement incorporating the form of contract in the MF1 terms, but didn't somehow deal with all the rest. And still, as yet, still don't have an answer as to how that works in law. The paragraph 73, the judge said, I decline to infer the parties' contract included the first draft. Firstly, Müller's letter of intent in its email, 13th of May, it's exactly what my learned friend was submitting, indicated that the final terms were not to be contractually agreed until signature. But that's the whole contract. So if that's right, then the whole contract falls. Secondly, the contract sent with the email of the 16th of May was designed to operate as a composite whole. Exactly right. So if for some reason there is an ambiguity in it that the judge regards as essentials, then the whole contract goes, not part of it. Thirdly, the parties did not proceed on the basis of the conditions. I've already made submissions that none of these actually are significant. Schedules 15 and 17 are indeed matters which Müller are responsible for. So what appears to be said is which are health and safety and training from memory. But if it's right, given the finding that the contract was meant to be a composite whole, the logic is that the composite whole fails. And then we're into clause 48. So whichever reason one relies on, it leads to the same conclusion that there was no contract. And that, as my Lord Carr put to me, and I apologise before I referred to my Lord as Lord Kerr, referred to as Lord Carr, so I apologise for that. But as Lord Kerr put to me, that is, I was constrained by what the judge had found. But this is another curious case because the judge's own conclusions lead to the exact opposite of the conclusion that he came to. And that's what the Court of Appeal accepted.
While we have this open, could I just ask you, in the section on performance, which begins at paragraph 53, these are the only findings about performance, aren't they?
My Lord, I believe that's right.
Yes. Well, if that's right, we'll just park that question for the moment. If that's right, I can't see any clear findings of actual performance, except perhaps the delivery of some free issue equipment on the 30th of June and delivery of components for line 1 on 5th of September. Is that right?
Would your Lordship...
Otherwise, it's just communications.
No, I think there's more than...
65?
65, thank you.
Well, yes, but that's...
Would your Lordships forgive me? I'll just take instructions.
65 is not very clear what
No.
delivery of equipment.
No, but not when. Not when. No.
I'm just checking the... It's... No, I think that the answer is that neither party gave a great deal of evidence as to performance, but what is in fact going on, as one sees from the programmes, perhaps that's the easy way of doing it, is there's obviously necessary precursors. Design is the critical thing. That's why it's being done at RTS's premises and why we get an advance payment. But I'm just checking to see whether, rather than me asserting it, we've actually dealt with that in the agreed statement of facts and issues. I'm not sure whether we have.
And taking up Lord Mance's point, any activities would have to be referable to actual duties and not merely preparatory.
Well, Lord, yes, and that's one of the problems with the...
Preliminary issues.
It's undoubtedly, and it's one of the problems. It's why I come back to clause 48. If clause 48 is a subject contract clause, then what it allowed the parties to do was sign off, albeit they're already performing, and apply it retrospectively. If it's a contract by conduct at some later date, that does alter the balance between the commercial entities, and that's one of the problems with what is being suggested at the moment. The answer, as it turns out in this case, is, I hope, as I said to earlier, that if your Lordship has determined clause 48 is not a subject to contract clause, or it's not a subject to contract case, then as at the 5th of July, everyone agrees we were agreed. There is performance even on those findings as at 30th of June, so by the time you've agreed at 5th of July, if that is sufficient performance, and that's the way your Lordships are minded to go, then 5th of July is still the date. What I'm anxious to do, however, is identify that there is a problem with clause 48, because it would be wrong of me not to draw that to your Lordship's attention, that there is a problem both commercially for clients, generally as a point of principle, and on the facts of this case, it's important to identify that both parties were really contending a contract, if there was one, it's 29th of June or 5th of July, for a pretty good reason, because things went wrong fairly rapidly after that.
It may not be clause 48 itself, it may simply be that the whole course of dealing between the parties showed that they intended everything to be subject to written contract.
It may be, and if that is one of the conclusions the judges came to. But if that's right, it's everything. That's the problem with the judgment. I'm just looking at the...
We wanted to find out what the actual performance was, not so much what the findings were. Where would we look?
I suspect the answer is going to be in this overall programme, which obviously postdates the 29th of June, which from a brief look at it shows a set-up period, which makes sense, shows a set-up period from 21st of February, which is the letter of intent, through to the 4th of March, followed by the kick-off meeting, 2nd of March, process MOFEA kick-off, design follow-up from 3rd of March through to the 24th of May, and then customer review meetings are shown, and then there's a build follow-up, which would be June, and then the design process starts on the 28th of February, and given that this is dated, I think it's 29th of June, is it? It's last dated 17th of June. I am assuming, but that is an assumption, my lords, it's showing an as-built up to that date, rather than, for obvious reasons, projected. And this is the contrast between the programmes. This is reflecting what actually had happened. So it is showing various activities which are principally design, which are taking place during the period of May.
Is that referred to in the schedule?
In the show, my lord, this is in the draft order, you remember my lord said there's a contrast between the approved programme. This is the later programme, which my lord, Lord Mance, I think, was asking for, is the overall project programme that the judge found formed part of his contract. And I believe Pinsent Masons have copies which they will make available to your lordships of this programme. I believe, from looking at it, it's an as-built up to a point in June, so it will tell you what activities are going on. But that is me asserting it, that isn't in evidence anywhere. Yeah. My lords, can I turn briefly to the law I've dealt, unless your lordships wish to go back to with British Steel and Percy Trentham. I've dealt with Percy Trentham in a number of ways. We're not disputing that what Lord Justice Steyn said is a very valuable tool in order to determine in certain cases, and may be very valuable in this case, but it's not the guiding principle in every case, and certainly not where one has a continuing stipulation. And the problem is it does lead to loose reasoning. Can I show your lordship very briefly the early facts in relation to the agreement on liquidated damages? Can your lordships please take part 2, volume 1, or 1 of 2, tab 23, page 468. And it also ties in the point my Lord Collins was making. It may be that the overall evidence was of a subject contract. Forget about clause 48.
Sorry, tab what?
23, my lord. It's helpfully part 2, 1 of 2. This is right back. There have been discussions, not only including RTS, but I understand with other contractors as well. But this is where Müller began to focus on RTS, 13th of January 2005. And this is RTS writing to Müller saying, second paragraph, following the meeting we've given a great deal of consideration to the issue of project timescales, and we've been able to make a significant reduction to our programme duration as recently advised to Mick St John. This has led us to consider the length of time required for the pre-order activities. One area of concern is the potential time it could take to reach agreement on the contract conditions should RTS be successful in winning the contract. As we discussed, RTS would be happy to enter into a contract with Müller based on the MF1 conditions plus appropriate modifications to adapt the form to meet the specific requirements of the project. Indeed, RTS has previously taken contracts on this basis. We are, however, concerned about the sheer extent and number of changes to the form in the Müller document because we feel that this could lead to a very protracted discussion which could cause delays to the programme. Our principal concerns with your original proposals are, broadly speaking, whilst we fully accept the importance of timely completion of the project, the proposed amendments to MF1 do not provide us with protection in the event of a change or delay not caused by us. Currently, Müller are not required to accept responsibility for the accuracy or timeliness of any information provided to us. No variation provision. And then over the page, the extent of our consequential and other liabilities is currently unlimited. And then missing a paragraph, I enclose for your consideration a copy of the contract conditions which applied to a contract recently carried out for RTS for a major customer in another area of the food industry. And he says he's edited them to remove confidential information, and it was a harsh contract. But basically that was the MF1 terms. That's how the amendment started off. But one can see instantly that the concern is with the very things which are all contained in the MF1 terms. If your lordships then go forward to the next tab at 486, on the 19th of January, so 6 days later, again right at the beginning, they amend their proposal following a meeting and say, second paragraph, please find attached 2 copies of pages 4, 5 and 12 of our document. And if one turns the page, 2.4 on page 488, liquidated damages provides for time-related liquidated damages, and then the one your lordships were concerned with on a learned friend submission is 2.42, performance-related liquidated damages, if the availability of either line 1, line 2, proven at the time of site acceptance test, is below the 95% quoted in section 6.4 and defined in section 7, which may be where the schedule 7 error comes in, and the causes for the reduced performance are entirely due to the fault of RTS, RTS will pay liquidated damages of 0.5% of the contract value for the element concerned, as detailed in the price breakdown section 2.1, per 0.5% performance loss of that element up to a maximum of 2.5%. So the original proposal had the cap of 2.5% and a 0.5% gradation up to that cap, which I think was in questions from Lord Mance yesterday. The way it ended up with Mr. Morrison's intervention was the 2.5% became a minimum and a maximum. The original proposal was to have a maximum with a scale going up to it. And then that is really effectively followed through in all of the subsequent correspondence. So if one goes forward to tab 26, and your lordship's sorry, this is the letter of intent, Roman 3, the key words again dealing with the issue of whether or not it's going to be so page 605 behind tab 26, my lord. The letter of intent, 21st of February, Roman 3. The full contractual terms will be based on Muller's amended form MF1 contract, and the full terms and the relevant technical specifications will be finalised, agreed and then signed within 4 weeks of this letter.
So the price and these terms were being negotiated at the same time?
Yes, my lord. The 607 behind tab 28, at the beginning of March, RTS was getting concerned there had been no meetings to take matters forward. And the letter says, due to the importance of the timescale for the automated pot mixing project, so that's why people start work, page 607, my lord. RTS agreed to commence work on the basis of a letter of intent prior to the agreement of a formal set of contract terms. So it was to assist Müller, in our case, that we started. The letter of intent is due to expire on the 22nd of March. Meanwhile, we are continuing in accordance with the agreed schedule and thus committing costs on your behalf. I reiterate that we are prepared to enter into a contract based upon either RTS's terms and conditions of sale, standard MF1 conditions, or, by agreement, MF1 plus appropriate modifications adapted to meet the specific requirements of this project. We remain concerned about the sheer extent and number of changes made to the form, the Müller version, back in October. That then prompted, at tab 29, 609, the first draft of what was then negotiated of the contract as a whole to be sent through by Müller to RTS, 15th of March. And when one turns the page, one sees, and one can see that from the markup that we've done, 611 from the outset, general terms and conditions, paragraph 4, set out in Schedule 1 will apply to this contract. 5, the principle of limitation of liability is accepted. 27.7, performance tests, the principle of liquidated damages is to be accepted, but what they've done incorrectly is to give damages on a performance test for a week delay rather than having it on by reference to the percentage failure.
So I'm lost now, which page you want?
Page 612, my lord, in the boxing clause. All of the things that are at the end of the project about limitations of liability, all agreed. And 27.7, instead of having 0.5% per percentage failure, if you like, the draftsman has incorrectly put in a time-based liquidated damages. He's just copied the delay to completion, and you'll see that we said that's not quite right. But the principle of it being a cap of 2.5% is accepted and agreed from the outset. The conditions one doesn't need to look at, but again, it contains all of the schedules, so it's clear that all of the documents your lordship's concerned with were intended to be part of this contract. And one then goes forward to tab 30. see there's detailed discussions, 649, 21st of March, where the note, one turns the page 650, under the heading Contract, Clause 5, the liquidated damages stated here are not as already agreed between us. And that goes back to the proposed amended schedule you've seen, because they got the wrong basis for the liquidated damages.
Sorry, clause 1?
Clause 5 says the liquidated damages stated here are not already as agreed between us. But then there are detailed discussions about the various clauses. I don't need to go through them. The tab 35 667, Mr. Morris enters the fray. Again, solicitor for Müller. Draft 2 of the contract, amendments marked in red. You'll note a number of amendments have been made in line with the discussions held at the last meeting. I suggest I arrange to contact you each in the next couple of days to reconvene a final contract meeting. In the interim, I will be speaking with Mick St John to see where the respective parties are in agreeing the various contract schedules that need to be completed. And of course, the contract schedules are the ones that go on, and that's the pattern that then follows on. And your lordships then get to tab 38. Sorry, 38. 5th of May, page 713. Again, comments coming back with actions agreed at the meeting. One turns the page, one has a detailed schedule where one sees the changes that are agreed or reissued, and one sees 714, top entry, right-hand box, dealing with clause 5, completion in Müller terms, and should be 0.5% whole week of delay for weeks 1 to 3, 1% for weeks 4 to 5, capped at 5%. That's delay damages. Liquidated damages for delays in delivery should be removed, if they were. Liquidated damages for performance shortfalls should be included. Need to agree how to measure this. RTS suggests this should be throughput. So the question was how you come up with a formula to measure the liquidated damages. And then, I don't go any further, because if one goes to 39, it's really the start of
What we've already seen.
what you've already seen.
Yes.
But right throughout, one can see in all of the drafts, the cap on liquidated damages is there, but read effectively from the outset. What happens later on in the story is when Mr. Morris amends Schedule 6, amends that clause 27.7, he starts referring to Schedule 6, which is where he clearly was expecting some kind of graded liquidated damages, but the cap always remains at 2.5% of whatever damages are due. My lords,
It's a question whether it's actually a genuine pre-estimate, isn't it? I mean, at one point it was going to be 0.5% per element, and then it seems to be agreed at 2.5.
it does, in this case,
It's more than £40,000. You just get that on by sending an invoice saying there's a shortfall in performance.
My lord, the answer would be there would no doubt be an argument. Once you've signed up to a liquidated damages clause, that is your only remedy. But your lordship is right. Genuine pre-estimate is more appropriate in the case where the argument is it's a penalty.
Yeah.
This is not dealing with that situation at all. It's in effect a cap on limitation of liability of RTS. It's just inappropriate use of language. That's the difference. And normally one would argue it's a penalty where
I mean,
damages for delay.
Well, I wondered whether it was a cap, because
It's a top, it's a max and min, isn't it?
yes. What does this link with? It says it links with 27.7.2, but you say that's inappropriate. It should be 27.7.1, should it?
Yes. And the
27.7.1 says you just send an invoice, and within 14 days you've got to be paid this sum as a genuine pre-estimate of losses suffered.
But then 27.7.2 in the original form, as is common in these standard forms, provided that if you hit the maximum amount of the liquidated damages,
Yeah.
the employer then has an option to terminate.
Yeah.
Mr. Morris put a not in there, which rather makes that clause insensible, incomprehensible, but the conclusion would be bizarrely, that he's actually amended out the remedy he thought he was going to get under Schedule 6, but that, if that is the agreed wording. But whatever else is agreed, there is a cap of 2.5%, contrary to what...
So these will be happy hours for future debates, will they?
There will be happy hours of future... I sadly get the impression that there will be happy hours of future debate in this case, whatever happens. My Lords, can I, conscious of the time, I said I would take your Lordships briefly to some authorities, conscious of the fact the Lordships will be giving guidance on some of these issues. And can I just show your Lordships briefly why I said that? And again, I stress that
just to illustrate the problem.
Illustrating the problem, and I'm not...
These are altruistic submissions for the future of the
They're altruistic
TCC.
because, if I was perfect frank, this is not an uncommon problem in the area in which I practice. And your Lordships will see that. And one of the particular problems, which I apprehend is true in certain types of commercial case as well, is the fact that in a construction project you are having very concurrent activities with concurrent obligations. And that's why it is important to define things at the outset and to have some sort of certainty. We get involved in all disputes largely because they don't have certainty. But what very often happens, as here, is you have these modular sorts of contracts where you have terms and conditions in one section, and then engineers or whoever else will draft the specifications, and you can guarantee that most disputes are as a result of that crossover, not meshing. And that is one of the reasons why I apprehend they have these subject to contract clauses in. Whether or not that is relevant in the present case, a different matter. When your Lordships are giving general guidance, it's something your Lordships may wish to bear in mind. But the starting point is Galliard Homes, my Lords. It's volume 1 of the authorities, tab 14. This was a decision of the Court of Appeal in 1999, and on the head note, your Lordships can see that it was a dispute between a main contractor and a subcontractor. The third sentence, on 9th of January 1995, there was a meeting between Galliard and the respondents Jarvis, at which some preliminary discussions took place. On the 11th of January, Galliard sent a contract preliminaries to Jarvis Interiors, a division of Jarvis. This included one of the standard forms. There was then, one drops down, on 14th of March, there was a letter of intent, in this case governing all work, which had a quantum merit expressly in it. And if one goes to page 221, one sees in the first proper paragraph on the page, the judge dismissed the summons, which is a question, an application for a stay to arbitration, for 3 not unrelated reasons. First, there was, in his judgment, no contract at all between Galliard and Jarvis. Parties were never ad idem. Second, such dealings as they had were in effect subject to contract, and hence amounted to no contract. And third, there was in any event no written agreement to refer the disputes to arbitration. One then goes forward to page 223. The penultimate paragraph on the page identifies the fact that under the heading 4.1 in the draft standard form JCT contract, it provided that the contract will be executed as a deed under seal. This provision will be returned to later as the basis for both or one of Jarvis's principal arguments and one of the judge's conclusions. And then goes forward to 225. The Court of Appeal dealt with, in the middle of the page, the letter of intent, and said on the appeal, no one has argued that there was as yet any contract between the parties. Moreover, I see the reference to a formal contract in the letter of intent as only adding force to a view, to which I shall return, that absent express agreement or necessary indication otherwise, there was to be no contract on the basis of the preliminaries, unless and until there was a formal contract, namely one in the context of those preliminaries under seal. And he then goes on to deal with Percy Trentham, and says, so long as no fault could fairly be attributed to Jarvis, they could always fall back on the not uncomfortable basis of a quantum merit. The presence of the paragraph also, in my view, denies the usual force to be attributed to the dictum of Lord Justice Steyn in Trentham, that the fact that a transaction is performed on both sides will often make it unrealistic to argue that there was no intention to enter into legal relations at all, events if the dictum is used to support the existence of some contract other than on a quantum merit. The judge then goes forward to page 234, and under the heading at the bottom of the page, the subject contract point, right at the bottom of the page, says the reference to the reasonable expectations of sensible businessmen was the judge's reference back to Trentham, in a passage to which he had earlier referred. As Lord Justice Steyn there points out, and as already mentioned, where work has been done and paid for, where, in other words, a transaction has been performed on both sides, it will often be unrealistic to argue that there was no intention to enter into legal relations. But no one would argue that because work has been done and paid for, then, without more, there must have been a contract, still less that there must have been any particular term within a contract. A further difficulty for Galliard in here relying on Steyn's dictum is the provision in the letter of intent that if there was no formal contract through no fault of Jarvis, the latter would nonetheless be reimbursed. And then he deals with the facts, so I think the audience needs to be troubled with. And then the next paragraph, as for a more legalistic analysis, the use of the definite article in preliminary 4.1.3 in context suggests, in my judgment, a clear requirement by Galliard, unless the contrary was either expressly agreed between the parties or arose between them by necessary implication, that whatever, if any, contract emerged in consequence of the invitation which the preliminaries represented, it would have to be under seal, and therefore also that the option afforded by the articles of execution underhand was excluded. A person such as Jarvis, and this is the certainty point, dealing with Galliard on the basis of those preliminaries, would in my view be entitled to proceed on the footing that, unless some antecedent agreement was expressly made, or could be inferred by necessary implication, then there would be no contract between it and Galliard on the basis of the preliminaries unless and until there was a deed between them. The effect was thus, in that respect, akin to the effect of the familiar phrase subject to contract, save it was more similar to the less familiar subject to formal contract, which is clause 48. And he deals with the effect of those clauses. And that is referred to in a number of the construction cases, because it does give rise a bit to, not necessarily a perfect solution, certainty, so the parties know where they stand. They can proceed on the basis, no contract until signature. And then, on a slightly separate point, page 237, under the heading, the section 32 point, which is the requirement in the old Arbitration Act that the arbitration agreement has to be in writing, Mr. Tattery tried to inventively argue that it had been agreed in writing by saying there had been some agreement to the preliminaries. And in the second paragraph under that heading, the judge says, in his first, he points out that the BTP schedule discussed on 1st December begins with a price. It's dealing with the submissions, which in turn included comprehensive printed arbitration provisions. This route is doomed. The letter of intent, as its name suggests, was mere intention rather than contract, and using its named price as a starting point for discussions as to price over 8 months later does not suggest that anything but its price was being used, even as a starting point. Moreover, the very preliminaries thus thought to be incorporated include the provision of clause 4.1.3 that the contract will be executed as a deed under seal. I fail to see how Galliard can claim to have the benefit of one part of the documents, which asserts for part of a contract alleged to have been made on the 1st of December, without it being stricken with the requirement of another part of the very same documents, that in effect the contract, if any, would be under seal. And that is exactly the same position my learned friend is in the present appeal. In the construction cases, there are perhaps two that the Lordships ought to see. One is on a Judge Seymour at tab 28 in the authorities bundle, because this illustrates some of the arguments that are being advanced, very similar to my learned friend's argument, simply on the basis of what Lord Justice Steyn was saying. Lordships don't need to be troubled too much by the facts. It was one sees from the first page, unfortunately they're not numbered, but paragraphs 1 and 2, this was a fire of a building that had already been constructed, and there were lots of disputes about who was responsible for it. if one goes forward to paragraph 143, one sees the heading the Costain contract issues. The judge can see it was a feature of the trial of preliminary issues, again a problem on issues, but although some issues were of direct interest only to Tesco and Costain, or only to Tesco and PHJ, each of Costain and PHJ sought, where it had no adverse implications for its own position to do so, to support the case of Tesco against the other. Nowhere was this more apparent than in relation to the Costain contract issues. While it seemed to me that the general nature of the case advanced on behalf of Costain by Mr. Tavern and Mr. Hargreaves was tolerably clear, namely that Costain only ever carried out work in connection with the store, pursuant to the terms of the letters dated respectively 20th and 23rd of March 1989, the material parts of which I've set out earlier in this judgment, which were characterised as letters of intent, there seemed to be a considerable amount of forensic mystification expressed both on behalf of Tesco by Mr. Roger Stewart QC and Mr. Graham Chapman, and on behalf of PHJ by Mr. Peter Coulson QC, now Mr. Justice Peter Coulson, and Mr. Derek Holwell, as to whether Costain could possibly be contending that it had not entered into any contract at all with Tesco in relation to the store. The position of each of Tesco and PHJ on this question seemed to be that it was so obvious that there was a contract that the contract could not be advanced by someone in control of his facial muscles. He then sets out the argument, which Lordships don't need to go to at the moment. Paragraph 146.
157 is the real.
146, my lord.
157 is the guts of it, isn't
my
it?
lord, yes. But it's the fact that he then draws attention to Panyan, Trentham, and then paragraph 149, a theme in the submissions of both Mr. Stewart and Mr. Chapman, and those of Mr. Coulson and Mr. Holwell, was that in order to find a contract, it was not necessary in law for there to have been an offer made by one party which had been accepted unequivocally by the other. And then it sets out the basis for that. 151, what both Mr. Stewart, Mr. Chapman, Mr. Coulson and Mr. Holwell seem to be hinting at least, in the passages quoted in the two preceding paragraphs, was that a contract came into existence as a matter of law, without more, provided only that the relevant parties were intending at some point to enter into a contract, and the terms of the contemplated contract had been agreed. In other words, offer and acceptance were not really relevant, and a contract could, as it were, be imposed upon parties as a result of negotiations between them, reaching a point at which nothing of substance was the continuing subject of discussion. It also appeared to be suggested that such a conclusion, namely that the contract had come into existence, was reinforced if the parties conducted themselves in the manner which would have been appropriate if the contract under negotiation had been concluded and come into effect. That's the performance problem. This approach to contract formation obviously ascribes little or no significance to formality as an indication one way or the other of an intention or not to enter into contractual relations, and seems to me to come close to disregarding the injunction of Lord Justice Lloyd in Panyan and endorsing the expression of opinion of the trial judge that it's the parties who are the masters of their own contractual fate. That is to say, those who must decide whether they wish to be bound contractually to each other, and if so, by what terms. In place of that approach, Mr. Stewart and Mr. Coulson appear to be contending, in effect, that if parties in anticipation of concluding a contract acted as if the contemplated contract had been made, that contract would be imposed upon them as a matter of law. Not only that, but in the circumstances of the present case, it seemed to be contended there should be imposed upon Costain a contract which was to be treated as if it had been executed under seal, because the contract being negotiated, if it had been concluded, would not, or probably would, have been executed under seal. He deals with, in 152, the standard approach at the moment.
More or less forever. I mean, this is a very, very long judgment.
Well, yeah, I'm not intending to read all, Your Lordship, please. The point I'm trying elegantly to make is that the courts are grappling with a very real problem where the tools that they need are certainty. And 152 is the English law of contract has evolved over many centuries in response to the needs of society in general and perhaps the needs of commercial men in particular. It is, in my judgment, a strong strand in the policy guiding the development of the law over the years The question whether or not a contract has been made should depend fundamentally upon the intention of the parties to the supposed contract, objectively ascertained, to make an agreement by which they desire to be legally bound. In other
It's very
words,
obvious, though, isn't it? Because if you do have performance, which is common ground, should be remunerated by some method or other, either, I would thought by contract really, but or by quasi-contract, all of a sudden you throw all this into the bin and say, well, you're only interested in negotiating the price. It's very peculiar.
well, Lord, that is the problem with giving the objective approach, maybe the right approach, the approach the law's always adopted, but if it is right, and I stress if it is right, that a subject to contract provision has the effect of precluding a contract coming into existence which is enforceable between the parties, that is their choice. The consequences of that, if they don't actually sign the contract, is a matter for them. It may be good or bad.
Well, but then the law has to decide what the consequences of that are.
Oh, exactly.
And then perhaps we should reimpose it all as terms of the quantum merit. That's my point. It's very, very odd for the law to say, well, in this kind of case where the work is actually carried out, to say, well, we'll throw everything into the bin, but we will say we will have the contract signed. That doesn't seem to me to be a coherent approach to the law at all.
Well, my Lord, as I have indicated, it is fundamental to these sorts of agreements that commercial terms are agreed. That the problem is that your lordships are dealing with two competing policies. One is that the common sense position is that commercial terms are central to a commercial bargain of this nature, and indeed essential, I would suggest. The other is the law gives effect to subject to contract provisions or like provisions. And the other case, if it helps your lordship, of Mr. Justice Ramsey, is currently the head of the TCC, who I was going to take you to, is exactly that type of case. And what they are saying is the law requires, if you are subject to contract, it's subject to contract. If it's equivalent subject to contract, that's it, even if you perform.
But what then?
Even if you perform.
Yes, but what then? What does the law put in its place? It doesn't say you can't have anything.
No, that goes back then to where Mr. Justice Robert Goff in British Steel goes on to say, in those circumstances, it gives rise to a quantum merit. That precisely.
But why doesn't the quantum merit, this is back to my point about quantum merit, take account of all these sort of terms?
My lord.
Because it's a very bizarre commercial arrangement to say, oh, well, you just look at the price as a sort of... I mean, here, for example, as I think one of the judges here, I'm not sure that this judge or the previous one didn't say, when you look at the price, you wouldn't take, there's some stuff about the letter of intent, you wouldn't take the price.
Well, if one
You'd
starts...
have something completely different.
The answer to your lordship's question is, as far as I'm aware, we would be embarking on virgin territory in relation to the precise ambit of quantum merit. As a matter of first principles, one would have thought that a principle of unjust enrichment, against the background of the general policy of the courts to do justice between the parties, would mean that the courts would regard themselves as having a relatively flexible tool to identify what they think is the fair result.
I can't identify the first principle that says if two parties agree that negotiations are going to be subject to contract, that precludes them from departing from that agreement later on.
There is no such thing, and I agree with my lord. The problem is, what these cases are saying is, most of the cases that the courts in the construction industry are concerned with are cases where the parties have performed what they anticipate will be the contract. And the courts are saying, in my submission that's consistent, it's not enough simply to have performed what you think you might enter into, because that isn't a clear and unequivocal waiver or acceptance of certain terms. And why I'm flagging it up to your lordships is that is the way they have approached these problems, because it does give certainty, however unacceptable it may be, to when I'm standing here and your lordships are in court, that is the way they say certainty gives these parties the knowledge that unless they do something pretty express, the mere fact of performance doesn't expose them to a finding that somewhere along the line that they can never actually determine at the time they're doing it, they've entered into a contract that they didn't think they'd entered into.
Well, if that becomes sufficiently entrenched in the industry, then you may say that that's going to be the understanding of reasonable commercial men.
But as I said to you, I'm really pointing these to lordships because I apprehend your lordships will give that guidance. My position, as I keep saying, is it doesn't matter which,
You don't
as far as
mind.
I'm concerned.
Very well, we'll adjourn until 2 o'clock.
Very good.